Hello and good evening. On behalf of the Vernon Area Library, I'd like to welcome you to Get Your Docs in a Row and introduce our guests, Karen Nadoff and Alan Press, attorneys with the Shire Law Group in Lincolnshire, Illinois, which is a premier estate planning and elder law firm serving the Chicagoland area for 25 years. Karen received her law degree from Temple University, where she was a recipient of the Outstanding Legal and Research Writing Award and was named Who's Who among American law students. Allen received his law degree from Loyola University Chicago and was awarded the American Jurisprudence Award in Federal Taxation. In addition to being a lawyer, Allen is a certified public accountant. Thank you very much and welcome, Karen and Alan. I will hand it off to you. As always, we are so happy to have you. And I am just right behind this little black square.
Thanks so much, Ashley. We just really want to thank Ashley, you and the library for having us and allowing us to bring this important information out to the community. So thank you to everyone who's joining us this evening for taking a part of your evening to be here. Please feel free to use that chat feature to ask any questions you might have. If we are going to cover whatever your question might be, we will let you know. So again, welcome to Get Your Docs in a Row. As Ashley said, I am Karen Nadoff.
And my name is Alan Press, and Karen and I are both partners at Shire Law Group, just down the street here in Lincolnshire. And we're very excited to bring you this presentation this evening. We hope you get a lot of great information. It's not geared as a sales pitch or anything like that. So there'll be hopefully a lot of good information and maybe some things that'll be new to you, or if you're already familiar with this area, it'll be a nice reminder of certain things. We do have our information up on the screen here. If after the presentation you have a question or want to follow up with us at all, our emails are listed here as well as our phone numbers. So feel free to get in touch with us at any time, and we'd be happy to answer any question.
So with that, we're going to get started. Just want to do an overview of estate planning. So what does estate planning do? It allows you to avoid chaos for your loved ones, protect the ones that you love, importantly, to plan the way you want, which we're going to emphasize tonight, and to prevent leaving choices and decisions to chance, putting you in charge of those. We want to start out by doing a brief overview of what estate planning is. Estate planning is the process of using an attorney to help you prepare for your future by planning for who you want your wealth, your assets, and your property to be gifted after you pass away. And the people that you're gifting to are known as your beneficiaries. In addition to who you're planning for, it's also about planning for how you want that wealth, assets, and property to be gifted to those beneficiaries after you pass away. Oftentimes people don't think about it. They think about estate planning as what happens after you pass away, but there's a very important piece of estate planning, which is planning for lifetime, for a period of potential incapacity. So estate planning is also about directing your health care and guiding your finances during your lifetime, minimizing or avoiding taxes, and minimizing or avoiding probate. Alan's going to talk about probate this evening as well. That probate can be time-consuming and expensive. So the documents that are part of your estate plan that we are going to be discussing tonight are your last will and testament, and that's known as a will. Also trusts, and Alan's going to cover wills and trusts. And then I am going to follow up with discussions on powers of attorney and healthcare directives.
All right, so let's start off with a last will and testament. And many of you probably already are familiar with what a will is. We've all heard of this before. We've maybe seen some stuff on TV or movies. So a will is a document generally that you create, and it states to whom you want to give your assets to when you pass away. It could be called a last will and testament. It could be simply called a will. Either way, it's a document that's only effective at death. And that's going to be an important point when you're kind of comparing a will to a power of attorney. When Karen talks about powers of attorney a little bit later, she's going to note that these documents are the powers of attorney are effective only during lifetime. A will is the opposite. It's only effective after somebody passes away. In addition to designating how you want your property to be distributed, it's also a document that can be used if you have minor children and you want to designate a guardian if something were to happen to you and you were no longer able to take care of your children. Who would that person be that's going to take care of your minor children if you were, unfortunately, if you were to pass away while they were still minors? And finally, a will is going to instruct the probate court of who you want to receive what. So there's that word again, probate. So let's just spend a quick second talking about probate and what that is. Probate is just the legal process to administer somebody's estate. So it was originally created with the idea that if let's say I pass away and I'm going to leave my assets to my spouse and to my children. But let's say I had a creditor out there. I owed money to a credit card company, and they probably want to get paid prior to my assets being delivered to my family. So, probate court is a forum where creditors can make a claim and say, before Alan's assets are distributed to his family, we'd like to get paid what is owed to us. So, probate court is a forum to handle things like that. It can also handle disputes. Maybe somebody creates a will and they leave one of their important family members out of the will. Maybe it was done on purpose because they didn't like them or didn't want to leave them anything. But that person also may want to argue that the will was not valid. Maybe the person wasn't competent when they made the will, or somebody forced them to write up a will that didn't include them as a beneficiary. Again, the probate court is going to be a forum for those types of issues to be raised and litigated if necessary. Probate is a court proceeding, so it involves lawyers, it involves time. It can become expensive because nobody wants to, pay for lawyers to go to court to do things if you could at all avoid that. So one of the goals in estate planning is perhaps to try to avoid ever having to go to probate. And there are some things that can be done to do that, which we're going to talk about a little bit this evening. And then just to define the term estate, that's just a generic term that means what do you have when you pass away? What are your assets? What are your liabilities? What are your obligations? All of these things kind of add up to make your estate. The problem with probate is that it's also jurisdictional. So Illinois probate courts can really only handle property that's located or assets that are located in the state of Illinois. So if you have, let's say, a home here in Illinois, you've got assets here, but you've also got a cabin in Michigan or Wisconsin or a condominium in Florida or Arizona, when you pass away, that might require separate probates in different states to handle all of those different properties. And that, of course, can make it even more time consuming and expensive. Probate in Illinois, without any major issues, is typically going to take 6 months at a minimum, up to a year. It could be less, again, it could be less than a year. It'll never be less than 6 months. But, again, that's only if everything is working smoothly. If there are complex issues or real estate that needs to be sold, or fighting among the family, or things that need to be litigated, of course, it can take much longer than that. We do illustrate a potential cost here of probate. Some probates can be less than this, but most are going to be in that range or even more expensive if there are problems or things to resolve. So, again, one of those goals that you might have when you're thinking about planning your estate is trying to figure out a couple of different ways that you might be able to avoid probate. And I will say that a couple of things will avoid probate automatically. Like, let's say I have a life insurance account, life insurance policy, and I've named my son as the beneficiary. Well, that's a contract that I have with the insurance company. So if I pass away, my son can fill out a claim form and submit my death certificate and be able to collect the proceeds of that life insurance policy. There's not going to be a probate needed for that. The same thing with beneficiary designations, maybe on a like a retirement plan. You could also have joint ownership, like a bank account could be jointly owned between myself and my spouse. If one of us passes away, the other one becomes the automatic owner without the need of probate. So there are things that can avoid probate. One of the other things to avoid probate is going to be a trust that we're going to talk about this evening. But the moral of the story is when you're doing estate planning, it's not just drafting documents or pulling something off of the internet. You actually have to make sure that your assets are set up in a way that they're going to work with the plan that you have put together. What happens if somebody passes away and they don't have a will? Well, then they are what is known as intestate. They've died without a will. And if you don't have a will when you pass away, lo and behold, the state of Illinois will have one for you. But without having a basic will in place, you're definitely going to be increasing the potential cost and time that it's going to take to administer those assets if there is no will. So if there's any assets that aren't jointly owned, they don't have a beneficiary designation, those are probate assets. And if you don't have a will, again, the state of Illinois is going to dictate how those assets are distributed. For example, if somebody passes away and they have a spouse and they have children, well, the law says that 50% goes to the spouse and the other 50% will be divided equally among the children. And that might sound pretty reasonable, I guess. But, for example, we did have a young family. Unfortunately, the father died and left a wife and two very small children. There was no will involved, and the husband owned the house in his name only because apparently the wife didn't have the credit or whatever to purchase the house, so it was in the husband's name alone. And in that situation, we actually had to open up three probates, one for the deceased husband and a separate probate for each of the two children who were minors, because you can't leave money to a minor. A 2-year-old or a 5-year-old is not going to be able to manage assets. So the court is going to want to supervise that and handle that money or monitor what it's being used for up until the children are 18. And then when the children turn 18, any money that's left in that guardianship estate will be distributed to the children. So in the situation I illustrated, basically mom had to purchase back half of the house from her own two children. And then that money from the value of the half of the house went into the probate estates for the kids. And that's probably not the result that that family would have wanted. I'm sure that if they did wills, they probably would have said, okay, if one of us passes away, surviving spouse gets everything. And if both of us pass away, then the money will go down to the kids. So intestacy can cause some very weird results. Of course, the best way to avoid that is to put together a will and make sure that you are setting up the distribution of your assets in the way that you want to. In addition, if you have no will, you haven't designated an executor. Who is the executor? Well, that's the person who is going to be in charge of carrying out the instructions in the will. And if you don't have a will, again, you haven't appointed anybody. So who can become what's called the administrator of the estate? Well, somebody who petitions the court to get that job. Now, there is a pecking order that the court will follow. So if multiple people attempt to become the administrator, they will give preference, of course, to the closer family members. But why leave that to chance? Why would you want that to be an open item? It's much better to have a will, designate the people that you want to be in charge and who you want to handle everything. If you fail to create a will, you're giving up that opportunity. You could also be creating a situation where there's fighting within your own family as to who's going to do it. And there could be disagreement. So these things can actually go to a hearing, right, to determine who is the most appropriate person in order to handle the estate. So if that can be avoided, again, that's going to be a benefit. So you definitely want to consider preparing a will as a minimum task to take care of for estate planning. The theme here this evening is you want to pre-plan. What you're going to notice is that if you take the time to do the planning in advance, you're going to avoid a whole bunch of problems potentially and additional costs down the road. And you cannot create a will after you're deceased, of course. And if you become incapacitated and you don't have the competency to create a will, it's also going to be too late to do a will at that point in time as well. So part of pre-planning is doing these things on a timely basis while you're alive and well and able to think them through and to make good decisions. That's going to be the best time to prepare a will. Let's now compare that to a trust. And you may recall earlier that I said a will is only effective at death. A power of attorney is only effective during lifetime. Now, a trust is actually effective during both time periods. So it's effective immediately upon signing. So it's effective during your lifetime, and it continues to be effective after death, which kind of makes it a little bit like a super document. So in addition to handling how you want your assets to be distributed after you pass away, a trust is also a great vehicle to plan for what happens if I become incapacitated. I get into an accident, I'm not able to handle my own financial affairs, but I'm not deceased, I'm just incapacitated. I'm going to want to designate somebody to manage my money and to take care of my financial matters for me while I'm incapacitated. So because a trust, is effective during life and death, it streamlines the administration of your assets during those time periods. A trust avoids probate. So that's a really big selling point for trusts. And because they avoid probate, they provide privacy. A trust will never have to be filed anywhere or open to public inspection, whereas a will is filed after death in the county in which you resided. So that's public record. If there's a probate proceeding, again, that's all open to the public. So if you have a probate going for a family member, your neighbor can show up at the courthouse and ask to see a copy of the file, and they can see, who's receiving what, how much money's in the estate. All of that is going to be public record. So a trust is going to maintain privacy. It never gets filed or recorded with the court. It's going to, unless there's litigation or a complaint about it, it provides maximum control. let's say you have beneficiaries that are minors. As I said earlier, they can't receive money outright. So there has to be a structure where somebody is going to manage those funds for the benefit of those children until they get older or to an age that you designate, which doesn't have to be 18. It can be any ages that you want. In addition, let's say you have older beneficiaries, but maybe you don't want to give them the money outright. Maybe they have, an addiction problem or something like that, or they're just bad with money and you'd rather have somebody else manage it for them. A trust is going to be able to allow you to set up that long-term structure that's going to allow for the protection of those assets. You can protect your beneficiaries from creditors. You can protect them from divorcing spouses. All of these things are goals that we work with our clients on to make sure that they're protecting the inheritance and the legacy that they're leaving for their family. Trusts also bypass probate, so you save money and time there, and you enable your trustee. A trustee is the person who manages the trust for you to carry out your wishes very specifically and without that court involvement. So that's a big selling point of having a trust. Let's take a look at a couple of terms. A person who creates the trust is called the settlor or the grantor or the trustor or the trust maker. All of those terms are interchangeable. In our office, we use the term grantor just because that's what we had in law school. But that's the person who sets up the trust. I'm going to set up a trust for myself. I'm going to be the grantor because I'm the person creating it. Who is the trustee? Well, the trustee is the person that's going to be in charge of the trust, right? So the trustee is the person who carries out all of the terms of the trust that you created. Can I be the grantor and the trustee? The answer is yes, and that's quite popular. If you're creating what's commonly known as a living trust or revocable living trust, I'm going to create a trust for myself, and while I'm alive and well, I want to be the trustee, so I'm going to put myself in charge. Now, I may have successor trustees. So if I become incapacitated or I pass away, I'm going to designate somebody else then to take over the trust as the trustee. But while I'm alive and well, I want to maintain control, so I'm going to be the trustee. And then finally, you have your beneficiaries. And your beneficiaries are the people that benefit from the trust, right? We all know what beneficiaries are. Can I be the grantor, the trustee, and the beneficiary? Again, yes, very popular. I set up a trust during my lifetime. I put myself in charge. And while I'm alive, I would like to be able to use my money and use the assets and the trust and be the one who benefits from it. Again, my beneficiaries may change after I'm deceased. I don't need to be a beneficiary anymore. So I'm going to have set forth my beneficiaries as to what happens after I pass away. So beneficiaries will change. But yes, I can be all three of them initially. Some true facts about trusts. They give you control as to how your assets are distributed. Trusts need to be funded. I alluded to this earlier that you have to not only create documents, but then you have to work with someone to make sure that you're setting up your assets to work with the trust, right? If you create a trust and you do nothing with it and there's nothing in it, it's not going to do very much, right? So this does happen, unfortunately. We have families that come to the office and they're like, Uncle Sam has passed away. And this should be easy though, because Uncle Sam had a trust. We take a look at Sam's trust and everything looks okay. But then when we look at Sam's accounts and assets, lo and behold, nothing is in there. So nothing was ever put in the trust. So funding is a fundamental part of this. We don't touch or handle people's money when they come to us for estate planning, but we do quarterback that whole situation. We work with the clients, we work with their financial people to make sure that after the documents are created, the assets are set up properly to work with the trust. The trust avoids probate. That's a huge one. Trusts are private. We already talked about that. And trusts are easy to administrate because there's no court involvement, there's no probate. Everything happens independent of court. So that's a big benefit because it's a way to save time and money. So again, the moral of the story is pre-planning, right? You cannot create a trust if you're no longer have the competency to do so or you're no longer alive. So you want to make sure that you are doing these things prior to facing a crisis, right? When you face a crisis, it might be too late. There are things that you can maybe do, but they're not going to be as good as if you took the time initially to get everything set up properly. So now I'm going to turn it over to Karen, who's going to take us through the planning for disability.
As we said at the top of the presentation, there's a very important piece of estate planning that addresses incapacity. So what happens if you become incapacitated? There's certain documents that can be put in place and should be put in place for that occurrence. So as Alan said, that trust does have the ability to plan for incapacity. So you can plan through your trust if you have a trust-based plan. You could also plan for incapacity through a power of attorney for property, a healthcare power of attorney, a HIPAA authorization, a declaration for mental health treatment, a living will declaration, and a DNR, which is do not resuscitate. So you can see that some of these documents have asterisks next to them. Those are health-related medical documents that make up your advance directives. So that healthcare power of attorney, the HIPAA authorization, if you have a declaration for mental health treatment, the living will declaration, and the DNR, those are your advance directives. We're going to take each one of these documents individually so we can give you some information about what each one does and the importance of having these in place. It is important to keep in mind that you must create these powers of attorney and these healthcare directives while you are able to make decisions for yourself. You must be mentally competent to create these documents. So once you become incapacitated, you lose that opportunity. We're going to start out with the power of attorney for property. This is sometimes referred to as a financial power of attorney or a durable power of attorney. At Shire, we call it a power of attorney for property. And this is property in the broad sense. So not just your home, not just real property, but anything financial in nature. So the power of attorney for property is a written document in which you are giving someone the power to make decisions on your behalf about your property and your finances should you become unable to make those decisions yourself. And the people that you are appointing in that position are known as your agent. Illinois has statutory forms for powers of attorney, and the statutory form has a listing A through O of what your agent can do for you. So they can do things like handling real estate transactions or dealing with insurance, retirement plans, business operations, if you have a business, estate transactions. Illinois, in Illinois, these powers of attorney tend to be strictly interpreted. So when we do these documents for our clients, we add pages of additional powers than what you might find on the Illinois statutory form. And we just wanted to mention some of those that we add, and we're going to do that for the next slide. So in addition to what the Illinois statutory form would give you, we add expanded powers, things like the ability for your agent to gift or fund a trust. So Alan just talked about funding a trust. That's coordinating your assets with your trust. We also add powers like long-term care planning, things as mundane as getting your mail. You know, if you're incapacitated and the post office is holding your mail, somebody's going to have to provide a power of attorney that authorizes them to receive that mail. We add powers like dealing with retirement plans and insurance, dealing with credit card companies. We add many more, but this is just a sampling of some of those things that we add, allowing your agent during a period of incapacity to easily be able to step in and help out with financial affairs if that's needed. And then once you are no longer in that situation of being incapacitated, that power of attorney might no longer be necessary. So it can come into play when needed, and then when not, it's no longer relevant. So, what happens if you don't have a power of attorney for property in place and you need some kind of assistance with your financial affairs? So, this can lead to some time consuming and expensive remedies for your family. Generally, if you haven't assigned an agent to act on your behalf, a court appointment of a legal guardian is going to be necessary. And anytime you're going to court, it is expensive, it's time consuming in the middle of emergencies and things that you're trying to do for a loved one. You don't want to worry about having to go to court and get that guardianship. Just by having your powers of attorney in place, you're avoiding that potential source of chaos. So if the probate courts appoint a guardian to legally oversee your financial affairs, it might be somebody that you didn't want in that position. Again, this takes time and money. It can lead to that additional frustration on top of dealing with an incapacitated relative. Again, just having them in place allows you to be in control of who's going to step in when needed. The next document that we want to discuss this evening is the healthcare power of attorney. This is also known as a medical power of attorney or a healthcare proxy. And again, at our firm, we call it a healthcare power of attorney or a power of attorney for healthcare. This is a written document in which you're giving someone the power, again, this person is known as your agent, the ability to step in and make medical decisions for you if you cannot make your own medical decisions. And importantly, none of these documents supersede or waive your right to make your own decisions. But if you're in the middle of surgery, you're going to want a healthcare power of attorney in place, naming the individual that you want to step in and make a medical decision for you when you cannot make your own. So again, Illinois has statutory forms for powers of attorney. And here we're looking at what the Illinois statutory form allows your agent to do for you. Things like deciding to accept or withdraw or decline treatment for a physical or a mental condition, agreeing to admit you or discharge you from a hospital, having access to your medical and mental health records and sharing those with others, and also carrying out any plans you might have. If you were an organ donor, plans for burial, that's also something your agent can do for you. Again, we always keep the statutory forms intact, but we highly customize them because there are some things that are missing that we think are important and give your agent the easy ability to hire a care manager, for example, to manage your care, or a companion if needed. We also add the ability for your agent to hire a patient advocate. Patient advocates are registered nurses that can be hired privately to support you. Maybe you need more information. You don't understand what's going on with a medical condition for a loved one. Maintain you in your residence if that's an option after you're released from a hospital. So this is just some sampling of additional powers that we add into the statutory form to make it easy for our clients, for the agents that they choose to step in and help out, doing things easily for them during that period of incapacity. If there's no power of attorney for healthcare in place, what happens? So under Illinois law, doctor is going to follow the list that we have here. You're going to ask a guardian of the person, if not the spouse, then any adult child or children, either parent, any adult brother or sister, any adult grandchild or grandchildren, a close friend, or a guardian of the estate. And again, the problem here is that person that's appointed might not be the person that you would have wanted. Additionally, these individuals, if they're appointed by the court, they're not going to be able to make decisions for you that you could have otherwise made on your power of attorney. On that power of attorney, you have the ability to mark down your choice as to termination of life support, for example. And there's other choices that you can make within that power of attorney for healthcare. You might disagree with the decision a family member makes. You might not agree with who the family members are stepping up to make those decisions for you. So again, having the power of attorneys in place are going to give you control over how decisions are made for you, and the agent that you want to name to carry out your wishes is going to be the one that's able to do that for you. The next document is your HIPAA authorization, and that's the Health Insurance Portability and Accountability Act. And most likely you have all filled out HIPAA authorizations. You fill them out when you go to your doctor's office. These are written documents that allow a healthcare provider to release and share medical information with the people you designate to receive the information on your behalf. So HIPAA is not a decision-making document. It's just about who is authorized to receive your protected healthcare information. And you can list as many people as you want as being able and authorized to receive that medical information. HIPAA basically says that you're authorizing the release of your protected medical information, including medical reports and records, to anyone who you've named as an authorized recipient in your HIPAA authorization. So what happens if you don't have a HIPAA in place? Well, it is a potential source of chaos, because if somebody calls up a hospital, a loved one calls up a hospital to get information about you, unless they're authorized to receive that from you filling out a HIPAA authorization, they're not going to get any information. So I've had an experience personally with this. My son was at school and he was admitted to an emergency room. I knew he was on his way there. A friend had taken him. And at the time he was admitted, his cell phone had no battery. And he was rushed back into a room because the waiting room was so crowded. So now he's in a room. He has no way of contacting me. They're not getting any information to the friend because the friend's not authorized to receive it. I called up the hospital. I said, my son was admitted. Can you give me information about what's happening? And they said, no, unless we have the proper authorization, we can't. So I had my HIPAA. I sent it electronically. And once it was sent, I called back, and at that point was able to get information about what was going on and what was happening. So it's a very important document. A standalone HIPAA is important because you never know if you're going to get admitted to a hospital you haven't been in before, and maybe at the time you're admitted you can't fill out their form. So these standalone HIPAAs are very important to have in place as well. And another healthcare directive is your living will declaration. So the living will declaration is a document which states your wishes regarding life support in the event you are in a persistent vegetative state or irreversible coma, you're on a ventilator, on life support, and you cannot communicate your own wishes. This document sometimes gets confused with your last will and testament, or your will, which Alan discussed, because it has will in the name. Sometimes it can get confused with your trust, because sometimes people refer to their trust as a living trust. This is, in fact, a healthcare directive that if you agree with what the living will says, you could have this in place as part of your overall estate plan. So the living will declaration says, if at any time I should have an incurable and irreversible injury, disease, or illness that's judged to be a terminal condition by my attending physician who has personally examined me and has determined that my death is imminent, except for death delaying procedures, I direct that such procedures, which would only prolong the dying process, be withheld or withdrawn, and that I be permitted to die naturally with only the administration of medication sustenance, or the performance of any medical procedure deemed necessary by my attending physician to provide me with comfort care. So if that is a statement that you agree with, you could have a living will declaration in place as part of your overall estate planning documents. We do want to mention that with all of these documents, all of these powers of attorney and healthcare directives, electronic documents can be sent to wherever they need to go. So when we do these documents for our clients, we always have originals that we give to them, but they also have electronic copies that they can download and keep in a safe spot just in case it's needed. These can be sent to wherever they would need to go to. The other question that sometimes we get is, how do we know who to name for agents under our powers of attorney? And we always say, name the person that you would want to act today. So, even if they are out of state in another state, or if you feel like, they're your same age, you want somebody younger, put the person you would want first as of today, and then list the next person you would want if that person was unavailable. So that's the best way to think about that. Not knowing who you want to list for your agents should not stop you from putting these documents in place. Again, you have to create these powers of attorney and healthcare directives while you are still able to make these decisions for yourself. So again, a common theme that we'd like you to take away from today's presentation is plan ahead. You don't want to be in a position where you're crisis planning, especially with these powers of attorney and healthcare directives, because they have to be signed when you're mentally competent to create them. We did want to also touch on the DNR. The DNR is a do not resuscitate, and sometimes this document is also confused with that living will declaration. The DNR is a medical document or order. It's a physician's order, which tells doctors not to restart your heart or your breathing. So if your heart stops or your breathing stops, normally you're going to be given CPR. But if you have a DNR in place, you're saying, do not do anything to resuscitate me. Again, it has to be signed by your physician. If you would want to be resuscitated, you do not want a DNR in place. So why would somebody want a DNR in place? They might be at the end stage of a terminal illness, very advanced in age and not well. Or maybe it's a situation where they've had numerous heart attacks, and if they have another one, they just don't want any attempts to restart their heart. So these are a few examples of why you might want that DNR in place. And again, it would come from your doctor. It is a doctor's order. So the solution, pre-plan. Pre-planning allows you to appoint the agents that you want to step in on your behalf should you need assistance with financial affairs, or if you cannot make your own medical decisions, you're directing who can step in and make them for you, not leaving it to chance. These documents ensure that you provide specific powers for your agents, so it's very easy for them to act on your behalf if needed. You can, within your power of attorney for healthcare, provide direction as to your wishes for life-sustaining treatment and other personal choices. Under your HIPAA, you can decide who's going to be authorized to get your protected health information. And these give your agents decision-making ability and allow you to have documents in place while you have that mental capacity to authorize your agents and your agents' powers. So there's some additional sources of chaos, and Alan and I always say to look at this from the practical side of things, because we've had so many situations where somebody has come into our office after somebody is incapacitated or they're passed away, and they have no idea from a practical standpoint what bills are out there, what's paid online, things like when are those bills paid, how are they paid, how does someone get into your home or apartment to take care of household affairs, or what if there's a pet that needs to be cared for? How does a funeral get paid for? How do your wishes get known? And where can important documents be found? So during a period of crisis, the best thing that you can do and a gift that you can give to your loved ones and the people that are important in your life is to have estate planning documents in place in addition to a resource where you have listed all of these different practical things that somebody would need to know should something happen to you. So we have created for our clients something called a roadmap to collect all this practical information. We wanted to share with you this evening the different pieces of our roadmap so you can create one on your own. So one of the first things that we have in the roadmap is a list of important contacts. So if you have an accountant, an attorney, an insurance agent, a financial advisor, list their names, how to get in touch with them, emails, phone numbers, the location of your important documents, any of estate planning that you have, your will, if you have a trust, your powers of attorney, your healthcare directives, also where you keep your tax returns and records. If you have insurance policies, where do you keep those? Deeds to your home, automobile titles. So any important documents, where is the location of that? We also recommend having some type of personal financial statement that lists your assets. If you have stocks, bonds, real estate, your bank accounts, retirement plans, cars, any assets that you have, along with beneficiary designations, if that asset is held in a trust or jointly. And then also information about any kind of debts you have, or is there mortgage on your home, credit cards, any debts. So whoever would need to pick up will know this is what you have out there. This is what needs to get addressed. We also would recommend having an inventory of digital assets, your email account, online banking, brokerage accounts, online photo galleries, social media accounts, and important to have login and password information as well, so anyone who needs to access these different accounts can easily access them. And of course, you want to put your roadmap someplace that's safe, so that is also a piece of this as well. Also, computer passwords. So somebody has to be able to get into your computer if things are done online. And home security system codes. How does somebody get into your home? If you have a safe combinations, and the location of like a home safe. If you have a safety deposit box at a bank, where are the keys to that? And one other note about those safety deposit boxes, if you do have those at a bank, it's always a good idea to name somebody who's authorized to access that bank, safety deposit box, because it is very difficult to access after something happens to you if an individual is not named on the box. So just something to think about as well. Also, we recommend having the location of family heirlooms or other valuable personal property. So the roadmap is an opportunity to also write down why this family heirloom is so important. I have a vase that's been passed down through my family, and I have in my roadmap why that vase is important so that doesn't get lost. And also information about funeral arrangements or burial wishes. And this is one that Alan and I always recommend that you discuss ahead of time, because sometimes people don't get to your roadmap until after a funeral has been planned. Things tend to happen very quickly when somebody passes away. So you want to make sure that your wishes are known, they're in writing, but also you verbalize them to somebody who would be in charge at that point. And then, of course, miscellaneous instructions like don't forget the cash that I have hidden under the mattress or in the can that's buried under the backyard, anything like that as well. Additionally, it's an opportunity for you to put any notes to loved ones. The roadmap is just all encompassing of anything that somebody would need to know or you would want them to know. So this is a way to drive your estate. First, getting all of your estate planning documents in place, and then making sure you have that practical side, the roadmap as well. So, avoiding chaos, again, the theme is pre-plan. When you have these documents in place, you're directing your own choices, your own decisions. They're relatively easy to put in place, and it avoids you leaving things again up to chance and somebody else deciding what may be happening to you in a situation where you can't make your own medical decisions or you can't control your own finances, and certainly through a will or a trust guiding who your beneficiaries are and how they are going to receive the assets and pieces of property that you're going to be leaving for them. Any questions? You can drop those into the chat. We're happy to answer any questions that you might have.
We definitely talked a little fast, so
Yeah, I realized that. I'm like, oh,
7:19.
yeah. And also, if you have questions after the fact, please feel free to contact us. You can email us, you can call us. It's very important to us that, everyone on here understands how important this information is. And after the fact, if you're thinking about something that we discussed and you're not sure about it, or you want a little bit more information, we are always happy to answer any questions that you might have.
I was thinking that, you guys are so good at this presentation that you probably heard all the questions. So you've done a great job at kind of honing the information and making sure that you say what you need to say the first time that you say it. So as mentioned, Karen and Alan are just wonderful people, and they are absolutely available to answer any questions that you have. I strongly encourage you to reach out to them if you do have any questions. We just had one that came in. It says, what is the effect if parents are snowbirds between Illinois and Florida?
Yeah, that's a great question. So, it depends on where your residency is going to be. So, if you're Illinois residents, I mean, that'll have certain implications for the way you might set things up. It'll certainly have implications for maybe some estate tax considerations or concerns, because Florida does not have a state estate tax, and Illinois does. So that's something you certainly would like to address. But other than that, estate planning that is put together is typically going to be universal. So if you live in Illinois currently and you do your estate planning and then you move down to Florida, let's say, you typically don't have to update very much, if anything. You may want to get the localized powers of attorney, but other than that, any documents that you prepare in Illinois should be fine if you move to any other state. Of course, you always want to just double check that to make sure, because there are 50 states and there might be certain things you could take advantage of if you do change your residency. But yes, many of our clients are go between Illinois and Florida. Illinois, of course, does not tax any property that's in Florida, on the estate tax. But that's a fairly complicated subject and can be a discussion in and of itself for more than an hour, but there's certainly some nuances there.
We had another question.
Oh, yeah, go ahead.
Yeah. Can a living will be in my medical POA document? Actually, in your power of attorney for healthcare, there is a choice there that is similar to that standalone living will declaration where you get to provide your preference for how you would want your agent to make a decision for you should you be on life support or life sustaining treatment. So it is in fact part of that power of attorney for healthcare, and you do have an opportunity to direct your wishes through that power of attorney for healthcare for that situation.
Yeah, I think there is some redundancy between the two documents in that sense, which is a good thing. So the living will is a standalone declaration of what your wishes would be. As Karen pointed out, that healthcare power of attorney is going to be a directive assigning somebody to be your decision maker. And on that form, you can give guidance as to what your thoughts are regarding life sustaining care. So your agent that you have named will have that available to them. But I will circle back to what Karen made a great point about discussing these things with your family, because in a time of crisis, sometimes they don't necessarily look carefully at the document. So making sure that your loved ones know what your feelings are on some of these issues is going to be a great advantage for you and for them.
All right. One final just sort of thought before we let everybody out for the evening is I wanted to plug a similar program that we partner with the Shire Law Group on. I believe it's in the fall, right, guys? The Stevenson What to Do When Your Child Turns 18 program.
Yes, September 23rd.
Okay, there we go. So if you are interested in learning a little bit more about what to do when your child turns 18, if you have that type of situation, please consider registering. I believe that one is also exclusively online. I can't
I'm
remember.
not
Is
sure
it
about
in?
that.
Okay. But yeah, so that'll be in the fall newsletter, which is dropping pretty dang soon. So look out for that. And as always, thank you guys for being a great library partner, and we always appreciate you and your time.
It's our pleasure. And again, Ashley, thank you so much to you and to the library. It is always a pleasure being able, we live in the community, so it's also our library. So we're very passionate about being able to present, and we appreciate all of your coordination to get us here. So thank you.
All right. Good night, everyone.
Night,
Thanks,
everybody.
everybody.
Thanks for
Bye-bye
joining
now.
us.